Protection Visa 101. There's nothing more terrifying than knowing that if you're sent back home, your life could be in danger. But for thousands of people currently residing in Australia, that's a reality. Now, we've helped countless individuals in this exact situation. People who have faced threats of harm, persecution, violence, or worse, if they were to be returned to their country of origin. But even when the threat is real, your protection visa application can still be refused. This is because many people either miss a key detail, apply too late, or misunderstand the process entirely. In this video, I'll walk you through exactly what a protection visa is, who qualifies, how to apply properly, and most importantly, what you should not do in your protection visa application. Hello everyone, this is Walt Collis, your trusted Australian migration lawyer. So who is this visa for? The Subclass 866 protection visa is only available for applicants who have already entered Australia on a different substantive visa, such as a visitor or a student visa. You cannot apply for this visa if you are outside Australia. Different options exist for people in that scenario, which we'll cover in another video later down the track. The Australian government has strict rules on who qualifies, and missing even one small requirement on the application could shut your case down before it even begins. If you believe you would suffer a risk of harm, persecution, unlawful incarceration, or serious bodily harm due to your personal characteristics, think religion, sexual orientation, political affiliations, upon being returned to your country of origin, then you may have a valid claim for protection. But there's a catch. If you've ever held a temporary protection visa or a safe haven enterprise visa, you're not eligible for this particular visa. Same goes for people who've had a protection visa canceled or refused before. And even if those procedural aspects do not hinder your application eligibility, you still need to meet health, character, identity checks. That means no false documents, no criminal red flags, and no skipping your current visa expiry date. You've got to play it by the book. Additionally, you must also sign Australia's value statement. It's a standard part of the process, but skipping it or refusing to comply could get your application refused. So the step-by-step application process. Step 1, gather the right documents. You need to start by collecting your identity documents, travel history, note down all relevant details of your entire address history, employment history, and education history as well. Most importantly, you need to provide evidence of your claim for protection. That includes police reports, medical records, threatening messages, anything that proves that you're at risk. You'll also need a clear, detailed, written personal statement that explains why you're seeking protection, why you can't go back to your home country, or why you can't relocate to a neighboring country. This isn't something you can afford to write casually. The department will examine your story line by line and likely question you on it during the interview stage. Step 2, get legal advice early. So most people don't call a lawyer until it's too late, after they've already submitted the wrong documents or missed key details in the story, or they've stumbled through the interview by themselves. And by then, the department starts questioning your credibility. And once doubt starts to creep in, no amount of paperwork can clean it up. The protection visa is about building a case of a visa applicant meeting Australia's legal definition of a refugee or someone who is owed complementary protection. So fumbling the process during the preparation phase can easily get you refused. Step 3, submit the application and pay the fees. So once your documents are ready and your case is strong, you'll submit your application online via the Home Affairs online portal IMI account. Now keep in mind, it won't be processed until you've paid the visa application fee, but your lawyer will issue you an invoice for the professional fees separately. Make sure you keep a record of your transaction reference number, or TRN for short, because it will be used for tracking everything that happens next. But even after you've submitted everything, you're not in the clear yet. But what happens after you apply? So, once you submit your application, there's a waiting period that can range anywhere from 1 month to 3 months before you receive the first correspondence from Home Affairs. They will send an acknowledgement letter confirming they have received a valid application, which will usually get sent to your migration lawyer. This letter confirms that your application has been received, and it will outline what happens next. But from there, the process can move quickly. You'll get an email asking you to complete a health exam. This isn't optional and must be completed within the stipulated time frame. You'll receive what is called a HAP ID, and that's your unique health identifier, which you'll need to schedule your appointment through an approved clinic. The exam includes blood tests, a chest x-ray, and a general physical. But if you delay this step or you miss the deadline, your application could face significant delays or worse, get refused. Biometrics. So next you'll be asked to provide biometrics, which means a digital photo of your face and fingerprint scans. This applies to you and any family members included in your application. You'll need to attend a biometric collection center and bring your passport as ID. If you skip this step, the department won't process your visa and deem your application invalid, which is something you definitely want to avoid. The interview. Now comes the part that most visa applicants underestimate, the protection visa interview. So, you're called in for an interview several months after applying. You walk into a government building, there's an immigration officer across the table. They've read your application, they know your claims, now they want details. They'll ask specific, pointed questions. They might go over your timeline, ask about people you've named, or challenge parts of your written statement. This is not the time to guess or improvise. It's your chance to clarify your claims, but it's also where many applications fall apart due to inconsistencies or vague responses. Ongoing communication. After the interview, it's not uncommon to hear nothing for weeks, even months. That just means your case is still under review. At this stage, Home Affairs may request additional evidence, updates to your documents, or clarification on certain claims. If your situation changes in any way, even something as simple as changing addresses, you must notify them immediately through your legal representative. Common mistakes that can get your visa refused. There are things that can get your application rejected even at this stage. Mistake 1, inconsistent or vague information. So let's say you're writing your application that the threats of harm started in March. In the interview, under pressure, you say it happened in May. That tiny little mismatch is now a major credibility issue. Or you say you were threatened by the police, but forget to mention the part where you also got a warning letter from a political group due to your political affiliations. That missing context could be the reason the department decides your fear isn't well-founded. If your story changes at any point, even slightly, it can look like fabrication, even when it's not. That's why preparing your statement with a lawyer from the beginning matters. Mistake 2, missing or weak evidence. Now imagine you were part of a serious event back home, like a raid, an arrest, or an assault. But there's no police report, no photos, no hospital records, just your words. Now sometimes that's all you have, and we've worked with those cases before. But when you deliberately don't provide the evidence to back your story up, the department has to make their own assumptions. Even supporting documents from friends, relatives, or community leaders can help establish that your fear is real. But don't assume that Home Affairs will give you the benefit of the doubt. Assume they will question everything and prepare accordingly. This next mistake is actually the most common: rushing or submitting incomplete forms. You'd be surprised how many people forget to sign a value statement or skip a health question because it felt not relevant. Incomplete forms can lead to automatic refusals. The department doesn't follow up or ask you to finish them. They just assess what's in front of them. If you're not sure how to answer a question, don't guess. Ask your migration lawyer. One wrong word can make it look like you're hiding something, not attending the interview or the medical exam. So picture this, you open your mailbox and see a letter from Home Affairs. It's your interview date for the protection visa application. But you put it aside thinking, I'll deal with that later. Life gets busy. You forget, maybe something serious comes up and you miss the appointment entirely. Home Affairs don't always accept late replies or missed interviews, even if there might be a good reason for the delay. And just like that, your whole application could fall apart. Unless you reschedule properly, give notice, the department can make a final decision based on whatever limited information that is available to them. Same goes for health, biometrics. Missed the window, your case may be decided without you, and almost always that decision will be a bad one. Even if you've done everything right, you've gathered the right documents, you've followed every step, you've avoided every mistake, your application can still be refused. So why can legal help save you? A lot of people fail to prove their claims. They panic, they end up saying the wrong things. Most people applying for a protection visa aren't legal experts, and they shouldn't have to be. You might know you're in danger, but unless your claim meets the legal threshold for refugee or complementary protection, it won't be approved. A lawyer helps frame your experience in the exact terms that the law requires. Home Affairs won't tell you what's missing. They won't flag that your timeline doesn't make sense. They just assess what's there. And if it doesn't meet the standard, they refuse and move on. So a lawyer can fix those mistakes before Home Affairs even notices them. Also, immigration law isn't static. What applied 6 months ago may not apply now. Legal professionals stay updated, so your case isn't built on outdated assumptions. Now look, I know, the protection visa process is complex. Stakes are high, and a simple mistake can cost you everything. But with the right legal support, you don't have to navigate it alone. Book a consultation with Australian migration lawyers today by clicking on the link in the description. So let's review your case, build a strong strategy, and give your application the best possible chance of success.